Hey guys. Hello, hello, hello. I forgot to take my camera off. I had my PJs on. It's a PJ day, y'all. It's a PJ day. Hello, hello. Let me say hello, everybody in the chat. Let me get going. Hey, Galatian. Hey, Pretty Brown Eyes. Black Beauty. Kimberly, I said Black Beauty, but I meant you. Kimberly, hey Kimberly, hey Nakenya, hey Bev, hey Lady Coltrane, hey Nosy Rosie, hey Pretty Cat, hello BK, hey Mika, hello Trissy, hey Toria, Black Beauty. I said your name and you weren't even here at the time. Hey, good morning, everybody. Good morning. All right, I'm going to go ahead and get started because this transcript is pretty long. And as I was explaining to you guys yesterday, this is where the judge made the ruling on the suppression of certain items in the case. So, and I spoke with a couple of people recently, and they were expressing to me how in the world that this case could still be going on when there are so many things that has been thrown out in regards to Young Thug's side of it. Now, the other people, there's some people who have already faced the charges and they've been convicted of the crime and they are serving time. Those people, we don't quite understand why they were added onto this case, but we're not the law. We're not. We're just spectators on the side. So what I'm going to do without any delay, I'm going to start the reading of the transcript. You guys, I'm going to try to do different parts. Okay. When I have that deep voice, I'm talking about Judge Glanville. I don't know. I'm just going to try to change some type of voice, okay? So you guys can keep up with who I am, okay? I'll just say judge, court, whatever, and tell you who it is, okay? So let's get started. Good afternoon, everybody that's coming in right now. Let's get going. Okay, this is a transcript from that court appearance. All right, let's see. State of Georgia versus Jeffrey L. Lamar, defendant. Excerpts, transcript of the motion to suppress. Number 1, supplement to motion to suppress number 1, motion to suppress number 2, motion to suppress number 3, and motion to suppress number 4. Before the Honorable Uriel D. Glanville, held on November 17, 2022, at the Justice Center Tower, Courtroom 8F, as in Florida. All right, we're going to begin. It says the appearance of counsel. You're going to have Adrian Love, Simone Hilton, John E. Floyd, Demetrius Smith, Lizzie Rosenwasser, which she's no longer there, assistant district attorneys. And then on behalf of defendant William, you're going to have Mr. Brian Steele, Keith Adam. Those are attorneys at law. All right, let's get going. And it says for the defendant, this is what they're going to have. The exhibit of accusation 16 SC 144444, right? And it's been tendered and it has been admitted. Then you have motion to suppress, supplemental motion to suppress, order granting supplement motion to suppress, motion for reconsideration, order motion for reconsideration is denying that order. I guess the prosecution put into deny. Okay. And it says motion for Noel Prosy, dismissal for want of prosecution, letter from Mr. Steele to Mr. Bailey, and warrant for search and seizure. All right. I'm going to be the judge. Y'all ready? Please hit the like button. Let's get going because I want to, get my acting skill together here. Here we go. Ready? This is the court. There is a motion for suppress number 2. What does that involve, sir? I'll ask you about 2 and 3 motions to suppress 2 and 3, Mr. Steele. Yes, sir. Okay, so, Your Honor, motion to suppress number 2 actually goes with motion to suppress number 1, as well as supplement motion to suppress number 1. Motion to suppress number 3 is goes with supplement motion to suppress. Excuse me. Supplement to Mr. Williams' motion to dismiss the indictment and or suppress evidence and derivative evidence, as well as original Mr. Williams' motion to suppress indictment. So 2 and 3 are separate issues. I can tell you what, as you asked, talking about, so 2 reference what? So number 2 reference motion to suppress number 1, as well as a supplement to motion to suppress number 1. What happens here, Your Honor, is the following. Mr. William was wrongly charged in accusation 16 SC 144444, and that was 1 count felony possession of marijuana greater than 1 ounce, than an ounce case. It evolved from an early morning hours. Mr. William was living in Sandy Spring, Georgia, at 315 Glen Lake Drive. Law enforcement officers are armed allegedly with an arrest warrant from DeKalb County for terroristic threat. So, law enforcement officers came to the Fulton County residence that I just gave the address to and supposedly served an arrest warrant. When they supposedly served that arrest warrant, they took Mr. William out of the home as well as several other people. And then allegedly when they are in the home, they see marijuana and other items of what they consider to be illegal activity involving firearm. And the law enforcement officer, they came with a search warrant. They maintained that property, came back with the search warrant, and then searched the property. And they take approximately 20, and I listed 11 electronic devices, including hard drives, computers, laptops, and cell phone. Law enforcement officers then, in 2016, went before the Honorable then Magistrate Judge Woodson. They obtained a search warrant for these electronic devices. Judge Woodson signed the search warrant. The law enforcement officer could not get into because of the code, a particular phone. It's an iPhone 6, and the IMEI number ends in 8463. So, the evidence stayed in the district attorney's office, specifically the Honorable Michael Sprinkle. He's a senior assistant district attorney at the time in Fulton County. The case got accused, and the accusation number that I just gave you with 1 count of marijuana possession felony. We argued that the case on a motion to suppress, I had the honor of representing Mr. William. We were in court in courtroom 1C of this courthouse. We argued a motion to suppress. The state was represented. Miss Love was actually one of the case, was on that case. It was argued by Senior Assistant District Attorney Charlie Bailey. The Honorable Judge Newkirk granted the motion to suppress all evidence from that search of Mr. Williams' home in July of 2015. Mr. Williams, the state asked for a reconsideration. It was denied by the Honorable Judge Newkirk. They never appealed that decision. The case is final. Mr. Williams sought his property back. It was not given to him. And instead, without telling Judge Woodson that circumstance changed, without telling any judge that circumstance changed, the evidence has been suppressed in violation of the statute that once evidence is suppressed, OCGA 17-5-30B, as in Barry mandates that the property be restored to its owner unless it's contraband. These devices are not contraband. The prosecution would not give the properties back to Mr. Williams' family member who had power of attorney. The prosecution sent the device that we're talking about, the iPhone 6 IMEI, number ending 8463, out of state to Cellbrite, CELLEBRITE company. They break the code after the evidence had been suppressed. The prosecution now has the content of that code. Approximately half of the evidence that we have looked in this case stems from looking at the breaking open of Mr. Williams' cell phone. He has standing. I have all of the law for you, and I have all the certified copies, and I would like to present them to this honorable court now, but you asked for an overview. So my position is on behalf of the Honorable Mr. Jeffrey Williams, is that prosecution, we now know, unlawfully entered his home. They unlawfully took his property. They did not give back the property after it's been suppressed in violation of Mr. Williams' constitution and statutory rights. Then they used that evidence in this indictment, and they used it against everyone here, because from there, that is where they get the videos that you are being heard of. They have items on the cloud because of that. They have text messages because of that iPhone. And I would like this honorable court to consider the granting of the motion. Here's the judge. What would be the motion to suppress number 2? Mr. Steele. Yes, but you also, just for convenience, Your Honor, it's also number 1. Ruth, somebody here for you. Hold on a second, y'all. The baby's doctor. The people are coming. Hold on, y'all. Listen to some music while I go take care of this. Hold on a second, y'all. lady who just came. Thank you. See you later. You too. You too. Hello? Hello? Okay. She's here. All right, guys, I'm back. I apologize for that. Peanut has appointment. So Ruth went, they had a person that comes and pick them up to take them to the appointment. Y'all, I'm out of shape because that running down those stairs. Whoo! Lord Jesus, help me, Father. Okay, y'all, give me a moment to catch my breath. Hey, pretty cat. Hold on, let me get some water here. Hold on. Got to catch my breath, y'all. Okay. All right. I'm Mr. Steele right now. I'm on line 4. If you go, those that's reading with me, line 4. Yes. But you also, just for convenience, Your Honor, it's also number 1. So it's called Mr. Williams' motion to suppress number 1. It was filed September 27, 2022. I then filed Mr. Williams' supplement to motion to suppress number 1, which was filed October 3rd, 2022. And then, yes, as this honorable court just said, it's Mr. Williams' motion to suppress number 2. I was reading Lady Coltrane's message. So be careful running around that house. Oh, it's okay, Lady Coltrane. I'll be careful. Y'all, if you notice, when I was at Dallas' house, I was sneezing and all that, the dog and all that. You see, right now, I'm cool. I'm home. I'm in my own space. Okay, sorry about that. Okay. We're at, and I thought I was being helpful to everyone, but they could have been grouped together. Your Honor, if I may, with the court's permission, may I get some exhibit stickers? Yes, Mr. Steele, did you get your exhibit marked? I did. Did you give a copy to Miss Love? I'm going to. Brief pause. Your Honor, may I approach? Yes, you may, sir. Okay. Okay, Mr. Steele. I have the accusation. What have you marked that as? I'm sorry. What have you marked that as? Your Honor, I gave the certified copies to Mr. Williams, number 1, number 2, number 3, and number 4 to the honorable court reporter. That is what I need to find out. Which is which? Number 1 is the accusation. Okay. Number 2, it should be in order. Motion to suppress any and all evidence located from Mr. Williams' home in accusation number 16 SC 1444444. I have that as D-2. Number 3 is the supplement to motion to suppress any and all evidence located in Mr. Williams' home, same accusation number. Number 4 is the order granting that. Okay. Any objection to D-1 through D-4? Madam, for the purpose of the motion? No, Your Honor. Thank you. D-1 through 4 are omitted for purpose of motion. Your Honor, just to make sure that we're fair to the court and understand what happened. So, the first, number 1, Mr. Williams, number 1, for today's date. Sorry, y'all. Hold on, I gotta turn this down. I hate people disturbing me because then I get lost in my spot. Sorry, guys. Okay. I'm going to read the judge's part again. D-1 through 4 are omitted for the purpose of the motion. Mr. Steele. Your Honor, just to make sure that we're fair to the court and understand what happened. So, the first, number 1, Mr. Williams, number 1 for today's date is one count accusation. The Honorable District Attorney Paul Howard, who was the district attorney at the time, and it charged Mr. Williams with possession of marijuana felony for July 15, 2015 incident, did unlawfully have under his control marijuana. If you look at the witness list, Your Honor, it's on the 3rd page. Is it, sir? Of Mr. Williams, number 1. You will see, I don't know if you are familiar with the discovery in the case, but it's the same discovery, same witnesses in the search for Mr. Williams' home at the address that I announced previously. So, what I did in that case, I had the honor, as the court knows, of representing Mr. Williams. So I filed a timely motion to suppress any and all evidence located from Mr. Williams' home. And I go through that in paragraph 1, and it's now Mr. Williams' Exhibit 2, certified copy that on or about July 15, 2015, law enforcement officers, included but not limited to Sandy Spring Police Department Detective Clutter, CLUTTER, applied for a search warrant for Mr. Williams' above referenced home, and the search warrant was signed by the Honorable Judge Anderson on July 15, 2015 at 10:36 a.m. Go through the facts of the affidavit and what it says. I take it apart. And take it apart. No, I'm sorry. And I take it apart in paragraph 2 and paragraph 3. Mr. Williams asserted that based upon the above, there was no lawful reason for the law enforcement officer to enter and search Mr. Williams' home when they were simply armed with an arrest warrant. So they had an arrest. I need to pause here for a minute, y'all. They had an arrest warrant, but they did not have a warrant for search. So that's what's happening here. They had a warrant to arrest Mr. Williams, right? But they did not have a warrant or a warrant to search the home. So what happens when they went to pick him up, they looked around in his home and saw some stuff in the home, and then they went and got a warrant to come and search. But see, they had already seen this stuff already without a search warrant. But you can't go after the fact. You should have had the search warrant when you went to pick him up. Should have had the arrest warrant along with the search warrant. You can't do it after the fact because you already seen the items in the home, so you already know what you're gonna go look for. So it's not legal. Okay. Okay, y'all ready? Okay. So I had to do a little break in there. Okay. Line number 12. Those who's following with me. And then, if Your Honor, you go to the wherefore clause, I wrote that wherefore Mr. Williams respectively requests a hearing on this motion to suppress, and the conclusion asks this honorable court to suppress all evidence, including the just over an ounce of marijuana, which is subject to the above referenced accusation number, and any derivative evidence obtained therefrom. What I did then was I supplemented that motion to suppress, and that is now Mr. Williams number 3. And what I have there, Your Honor, is going to be the same motion, except I added paragraph at the end, specifically paragraph 7. It's on page 4 of Mr. Williams number 3. And I added, moreover, law enforcement officers were not armed with a valid arrest warrant in the cab. So they didn't have a valid arrest warrant. That it was from a terroristic threat. Okay, at the time of the entering Mr. Williams' home, and thus all evidence must be suppressed. So they didn't have a valid arrest warrant either, y'all. Did y'all hear that? All right. So we went forward on the motion to suppress. That was argued before the Honorable Judge Newkirk. It was argued on the 3rd day of April 2017. Mr. Williams stood next to me in this courtroom, and we argued the motion, and that is now Mr. Williams' exhibit number 4, dated November 17, 2022. And the Honorable Judge Newkirk, after hearing from the parties, found and wrote, order granting supplemental motion to suppress and any and all evidence located from defendant's home. So everything that those officers got during that search, all of it has to be suppressed, even the marijuana and the gun charge. The gun. Y'all hear me? Everything. Because it says all. Okay? All. But the only thing is the marijuana and the gun, they can't get it back because they're not supposed to have it, but they can't use it against them. But they're not going to give it to them either. They're going to keep that. I don't know what they're going to do with the drugs. I don't know what they're going to do with the gun, but they're going to keep that. They can't even use it as evidence because everything that was found in that thing was found with the illegal search warrant. A search warrant that was not valid. Okay. So, all right. Let's keep going now, y'all. Let's keep going. All right. So the judge wrote that that supplement on the 3rd of April. So let's go down. Based on this ruling, the evidence located in Defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce marijuana, is hereby suppressed and cannot be used in evidence by prosecution in the trial of Mr. Williams. What that does, Your Honor, is that is finding of facts and law by the Honorable Court. Specifically, Judge Newkirk was not appealed. You hear? That was not appealed, y'all. What the state did though, is they asked for reconsideration. And that motion for reconsideration is important in our case, Your Honor, because what occurred today is the prosecution in their response is acknowledging that this evidence that they used in our indictment today was searched. But the prosecution position is that the evidence was never suppressed by Judge Newkirk, because the prosecution state that Judge Newkirk wrote that somehow only the evidence of the marijuana was suppressed. That's if the court, and I know this court reads everything. If this honorable court read the state's response, that's just wrong. First off, I was there. So I challenge everything and the issue. Okay. Here's the judge. Excuse me. Whatever has their phones on would put it on mute. Guess somebody's phone was ringing, y'all. Counsel, this would be a good time to mention this. For the next hearing, please do not give out the Zoom link. Oh, child, y'all, this is when they stopped the folks from watching, because they gave the Zoom link to other people, and the bloggers was up in the Zoom, and they were doing all kind of crazy stuff. You remember the naked person that was in there? They had the Zoom link. Remember the porn guy? Because they had the Zoom link, y'all. Remember that? Do y'all remember that? Hey, Wanda. Hey, 313. Hey, Sharon. Hey, VK. Do you guys remember that? That is why all that craziness happened. People was calling the judge. Folks was getting on the thing, showing their wee-wee and all this kind of stuff. Crazy stuff was happening because the Zoom link was given. And I think it was given when people went inside to, to get the what's the name? Like the filings, when you're paying for the filing, they had access to the ruling. The Zoom numbers and stuff, right? It wasn't closed. All right, here we go. Please do not give out the Zoom link to anybody but those who are but those who all but necessarily need to be on this platform. So that's where the ding ding guy came from, because he hit the link and they got on in there and they showed their stuff. Yeah, that's what happened, Tristy. I have to deal with this all day long. Do you hear that, y'all? The judge has to deal with the nonsense of these people coming onto the Zoom link with the nonsense. So, that was not cool. That was not cool for those people to do that, okay? People popping in. You see what the judge saying? I'm telling y'all, see? I didn't even read it, but I knew what the judge was dealing with. He says, I have had to deal with this all day long. People popping in, popping out. People popping in and popping out. And they want to come to the courthouse and watch the proceeding. And if they want to come to the courthouse and watch the proceeding, it's a public forum. They are welcome. But you're not welcome to go on a Zoom and act stupid either, okay? But we have way too many people who won't identify themselves. They're acting inappropriately. They dress inappropriately. See, I told you this is when the guy was showing his ding ding. I told you. I told you. And people try to put it on Young Thug. No, it was not Young Thug. It was the people that was up at getting the link and going in. You guys, y'all listening to this? See, they don't want to hear what the facts was, y'all. But I guarantee you, they have so many people putting out some fake narrative and getting thousands or hundreds of thousands of views, but not listening to the facts. Here's the facts. What happened? It was not Young Thug and his people putting a thing. No, because I heard those videos. No. Here's the facts. The facts was the link was given out for the Zoom, and people was popping in and out. Right? And the judge has to make some adjustment. That is the reason why. You can't wait to hit Diego. Okay, let me read. Let me finish reading so you can hear it. I apologize. You know, I like to do some commentary in the beginning. Okay, sorry. Let me go. Diego is basically telling me, shut up, Sylvia. Keep reading. Okay, I'll keep reading. They are welcome. We had, unless they are part of the immediate team or there is some special circumstances, meaning they are elderly, sick, or some other reason they can't get to the courtroom, I would please admonish you and just ask that you give out the particular Zoom information to anybody, not give out the Zoom information to anybody. Okay, that's what he's saying. He says, I would admonish you and just ask that you not give out this particular Zoom information to anybody. Okay? So please communicate that to those who are on your team for future reference, because it is getting to be a problem. Y'all hear me? The judge has too much problem with these people, especially these bloggers, y'all. Those bloggers was really wreaking so much havoc in that courtroom. That is why he prevented the going on live and all that kind of stuff that happened. It's their fault, people. It's their fault. They did a lot of mess. And the best thing the judge could do, and that's why my Rule 22 is being scrutinized so much, because they see me as a blogger and they're like, okay, is she part of this nonsense? No, I'm not part of this. I'm going to bring facts and truth. I'm not part of the lie committee. Okay? All right. So I had to put my little commercial in. Sorry, Diego. I'm back. All right. So he says for them to please communicate it with those people. Those who don't belong in there, do not get on the Zoom. Don't give it to them. Let's keep this clean so we can have a pleasant trial or hearing. Okay, that's what the judge is saying in my terminology. Okay. All right. So he says, so I ask you to do that. Please do that. I ask you that you please do that. And then Mr. Steele said, Your Honor, may I approach? You may. This is going to be Mr. Williams, number 5. And Mr. Williams, number 6, Your Honor. Is the motion for reconsideration D5 correct? All right. Then the order from Judge Newkirk, is that D6? No. Oh, the order denying it? Yes. It's D6. That's correct. All right. When I said it, the state's motion for reconsideration, that's correct. Oh, all right. All right, sir. So the reason I thought this was important is I'm trying to get, if the court wants it, the transcript of the hearing. I was at the hearing. I have heard this honorable court every time we're here. Before the court talks about lawyers with candor come before the court, I was there. I I know actually what I argued. I know how the judge ruled. But because I can't find the transcript yet, the state recently, and I'm not blaming them, but they recently filed their opposition to. So it's the first time I realized that they were raising that Judge Newkirk only made dispositive, whatever, the marijuana being suppressed. I thought it was important to try to give this court as much information as I can, besides my word on what happened. And if you look at Mr. Williams' number 5, state's motion for reconsideration, it's filed April 20th of 2017. It's filed by the Honorable Senior Assistant District Attorney Anthony Charlie Bailey. And what he wrote in the first paragraph, third line is, or second line, center, and respectively move this honorable court to reconsider its April 11, 2017 order, which is now marked, Your Honor, as Mr. Williams number 4, with today's date, granting defendant's motion to suppress evidence. It has nothing to do with just marijuana. The judge. I would agree then when the court issued an order as the suppression, especially regards to something like this, it would suppress any evidence that was taken at the time, at that point of time. Mr. Steele. Okay. And that is the issue there. And it's bore out by the motion for reconsideration. On the second page, Mr. ADA Bailey was right. It's in the last paragraph, second page, he wrote, both the defendant's motion to suppress and defendant's counsel's argument oral presentation focused on the argument that law enforcement officer lacked legal authority to enter the defendant's home in order to arrest the defendant, and that entry of the defendant's home was actually a search prior to obtaining a search warrant. Hold on, y'all. Hold on. Sorry, guys. I apologize. My apologies. Okay, it says here, the law enforcement officer lacked legal authority to enter the defendant's home in order to arrest the defendant, and that entry of the defendant's home was actually a search prior to obtaining a search warrant, right? That is what I argue. I argued that because the prosecution never admitted at our hearing before the Judge Newkirk the arrest warrant from DeKalb County, that law enforcement officers had no right to go into Mr. Williams' home. They were not armed with an arrest warrant. I challenged that. Remember, they were going in there because of terrorist a terrorist threat. Remember, that's what the search warrant, the arrest warrant was for. Hold on a second, I gotta drink this water. Hold on. The prosecution did not produce that arrest warrant, did not produce any evidence except there were statements which I objected to. They had an arrest warrant, and Judge Newkirk agreed and suppressed the entry into the home. When the law enforcement entered the home, that is when they allegedly see the marijuana, the guns. Then they go out and they get a search warrant to go in and take all of Mr. Williams' electronic devices. Court. If you are there illegally to begin with, you can't kind of listen. Here, this is what the judge said. If you are there illegally to begin with, you can't kind of correct it by going and getting another warrant. That is right, Your Honor. I'm just adding on, ad-libbing here. And then Mr. Williams, number 5, and I don't know if Miss Love remembers the case, but she definitely wasn't there at our motion to suppress hearing. But the reason I brought her up is on Mr. Williams, number 5, dated today's exhibit, that I moved into evidence. By the way, I don't know if I did that. I moved Mr. Williams 1 through 5. Any objection to D5 or D6, madam? No, Your Honor. Okay, they are admitted for the purpose of motion. And then on the last day of Mr. Williams, number 5 for today, Your Honor, Miss Love, always being professional, wrote to the... Hold on a second. Y'all listen to this. Gentlemen, are you here on Zoom? Listen, the platform may cut off in just a minute, so please be seated. She will reconnect you at 5. I should say 4:45. So if you get cut off, any of you who are in custody right now, who are in the platform, we will pause and then we will restart the system at 4:45. So don't go anywhere. Just don't get up thinking that we're done with you. We will reconnect to you in just a minute. And that pertains to anybody else on the platform that is necessary party for this particular proceedings. Okay, they pause. Any question? The game prosecution play, devils. Okay. Hey, Miss Sylvia. Hey, Lady Earth. Okay. Diego, it's a pause, Diego. Because I gotta watch my P's and Q's with Diego, boy. Diego be on Sylvia. All right, hold on, y'all. All right, now we're coming back. The judge. What's going to happen? The Zoom platform will cut off and Miss Yuma will restart it. So we probably should just pause right now so we don't get caught up. We don't get kind of caught in the middle sentence. Mr. Garland. Your Honor, I have no objection to Mr. Kitchen being released from the Zoom since our motion are complete for today. Mr. Kitchen, did you hear that? Mr. Kitchen, are you in the courtroom 3? Chamberlain. He's in courtroom 3. Mr. Kitchen. He's unmuted now. Mr. Garland, indicate indicate they don't have anything else for you. So you can be released at this point in time, okay? Okay. All right. Is that your desire, Mr. Garland? Mr. Garland. Yes, Your Honor. The proceedings stood for recess. We're on recess, Diego. We're on recess, Diego. Now, hold on, we can drink some water while I recess. All right. Mr. Steele, I think we're ready for continue at this point in time. Thank you, Your Honor. May I approach? Yes, sir. What do you have? Mr. Williams, number 7, number 8, number 9, and number 10. If you can identify them for the purpose of the record. Hold on, y'all. Hold on, y'all. Hold on, just got a message. Hold on. Even though I'm not there, I still get messages, y'all. Just bear with me a second. Hold on. Sorry. I'm a busy woman, y'all. I'm a very, very busy woman. Let me see what's going on. Just hold on a second, guys. I got a message. Sorry, guys. I apologize. Diego, don't get on me. Please don't get on me. Hold on. Somebody send me a message, Diego. Please. Hold on, Diego. Hold on, y'all. Hold on. Okay. Somebody tell me if I'm sick of reading, I can play this. Hold on. I'm gonna play it for you guys. They must be trying to look out for your girl, y'all. Hold on a second. Let me send it off to myself. Hold on. They looking out for you, girl. Thank you for the lookout. They trying to help Sylvia out. They said, Sylvia, I'm gonna help you out. Here's the link for the hearing on live. Hold on, y'all. Just 1 second. I got some good peeps on my side. They laughed at me. They're gonna laugh at you. Hold on. There it goes, y'all. I'm going to play it, y'all, to give you a break. What do you think will be the outcome of the trial? Diego, why are you going to ask me all that question? I plead the 5th. I don't know. But hold on, y'all. I'm getting ready to show you guys the thank you person. This is the actual hearing for that date. And I'm going to play it for you guys. Hold on. All right, here we go Here we go. This is him in live action of this happening. Okay, y'all, here we go.
Going down to line 3, it's on page 34, continuing. Mr. Bailey, the district attorney, on page 3.
Interrupt you a second.
Yeah, of course.
IT is about to create a new secure Zoom link, but it's only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks. Okay. I'm sorry, continue.
That's okay.
I apologize.
On page 3, 34, Your Honor, of Court's Exhibit 2, line 3. This is Mr. Bailey, the district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entering Mr. Williams' home. Then there are 2 parts here. And that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant, and what did they see once they got inside that would rise to probable cause? Then skipping, Your Honor, to line 21, same page 34. This is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve-out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went in home, they allegedly found marijuana, guns, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said at the end of line 1, Your Honor, or it's the middle of line 1, an arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within. The state is saying the entry into Mr. Williams' home was unlawful. He has his constitutional rights violated. He's a victim. The court should say respectfully, no way, this would litigate it. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct, and they could not enter the home. They affected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority, talking about the police, to go in to effect the arrest warrant. And then we get to the second point, and it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode. And then the prosecutor on page 36, line 25, concludes, that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom. And Detective Gaither further testified there were guns located in the living room. So that is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appeal. I am not respectfully required to do it again so the state can bring their A game, lose, and then bring their A+ game and try to win before this court. That's not the way, I don't get to do that, ever.
But it wasn't appealed. I mean, there wasn't, Judge Newkirk's ruling could have been appealed by the state, or could have been appealed by you within 30 days of the entry of the order.
Why would I appeal it?
Well, I know you wouldn't appeal it. But...
And the state doesn't appeal it. What does that mean? It becomes final. The court cannot amend that order. You'd be amending the finding between the same parties on the same exact issue. They don't get the second, in the case law, it says second bite at the apple. Then, Your Honor, on page 38, line 14, this is the district attorney again. So it's just not an issue that makes any distinction or any difference. It's clear here that it's clear here they, meaning the police, had authority to go in to effect the arrest warrant because Mr. Williams wasn't outside the house and he didn't come to the door. Once inside, law enforcement saw illegal contraband drugs, that is probable cause to get a search warrant all day long in any jurisdiction in the state. Your Honor, the police had no right to enter. That ruling was made. I then say on page 39 of the same Court's Exhibit 2, line 1, I get to speak. The court gave me the opportunity to speak. I said, thank you, Your Honor. Your Honor, we are traveling under, I'm assuming the court has it. If not, we'll get you a copy. There was a supplement to motion to suppress, and this is what I'm stressing, sir, the Honorable Judge Glanville, any and all evidence located.
They muted it. They muted it, y'all. They didn't realize they muted.
Lawful, and his arrest would be unlawful. And then the fruits of the unlawful arrest may not be introduced into evidence. An arrest warrant was never part of the record below. An arrest warrant not put in evidence was not put in evidence while the witness testified or at any other time. The participants in the suppression hearing referred.
Hold on a second. Crushy came in late, and Crushy wants to get us into a different spot. Okay, listen, Crushy. I was reading the transcript, right? And then someone was kind enough to send me the actual hearing, and that's why I'm playing the hearing, because I was reading the transcript, and they felt bad for me because, I was reading. So they send me this, and I said, oh, okay, I'll play it. But as I can see, the copy sucks a little bit. So that's what we're playing. We're playing stuff because today is an administrative day. There's nothing going on in the court. And I decided to come and read the transcript, because I got the transcript for you guys so we can go and remember some of the stuff that happened. If you could recall, yesterday I spoke of the things that he is requesting for suppression, and I was giving you the reasons and stuff like that, and just a reminder, helping you guys just helping you guys to refresh your memory, because this is good for us to understand what's happening. And sometimes we may need to go over the charges that he actually has and what was dropped and things like that, so you could get a full understanding of what's happening in court. Okay, I'm like a teacher, guys. I like to break it down to the lowest common denominator so you guys can understand and not make some crazy comments, crazy stuff, because I'm not trying to sensationalize anything. It's no sensationalize for me here. I like to just get down to the facts, educate, and help us to understand the legal system, because a lot of us don't. I don't. Well, let me just speak for myself. I don't understand the legal system, and I'm taking it like small bites so I can understand it. All right. And all of you guys that knows all this stuff, I don't know. Indulge me for a moment. And indulge those that don't know. There's quite a few of us that don't know all of this stuff. And if it's boring for you guys, I apologize, but I'm trying to educate myself on everything. Okay. So, and those who know the stuff, hey, by all means, let me know. Give me some information. I'm going to learn with you guys. Okay. Yes, it is your fault, Crushy. Oh, look.
Obscurely to the warrant, the warrant in the case. But there is no document to show that there is an arrest warrant. No judicial officer testified that he or she issued an arrest warrant. If the arrest warrant in existence, no reason whatsoever appears for the state's refusal to put it into evidence in the face of a demand. And I continued, I didn't write, I spoke. Page 41, line 1, Mr. Williams demanded in paragraph 7 of the supplemental motion and challenge that there is an arrest warrant. If there's no arrest warrant introduced in the hearing, then we go down the road in kind of an outline. So if there's no arrest warrant before this honorable court, which there is not, then law enforcement officers, according to Sergeant Gaither, 30 or 35 law enforcement officers surrounding his home, Sergeant Gaither, which is Gaither, did not go into the home. However, law enforcement officers entered this home. This honorable court has no evidence that they entered lawfully. Supposedly, he goes into Mr. Williams' bedroom. Now Mr. Williams is outside. So my first issue is the initial entry without the arrest warrants vitiates everything coming afterwards. That was my argument. On page 42, line 12, I argued to the Honorable Judge Newkirk. So my issue, I said, right, period. So my issue before this honorable court is the first entry, obviously without the arrest warrant at this hearing, is unlawful. Then the second can't be saved by the second entry either, because that would be without lawful blessing. Same thing as unlawful search, the second one we're talking about. Then the search warrant issue, this would be my third issue. So first one, no arrest warrant. I am challenging, it is clear to everybody, including when you read the state's motion for reconsideration that I've already entered, Your Honor, at the last hearing, everyone knew I was arguing that the entry into Mr. Williams' home was unlawful, and therefore everything in that home could not be taken, should have been suppressed and returned to Mr. Williams. And the
Y'all see that? We'll be right back. That's what they said. Channel 5 said, we'll be right back.
not even appeal. They didn't have the guts to appeal and say,
no, there we go again, y'all. There we go again.
Break into the devices. I mean, what?
I have to beat some of you guys up. Y'all come in here late. Johnny come lately, and then you go. I know you just asked a question. I'm gonna get into Bobby. No, I was Bobby, I'm just messing with you. No, I was yesterday. There was a motion submitted by Mr. Steele in regards to suppressing some items, and so what I was doing is basically kind of like doing like a recall, bring back to your memory and things like that. You know, that type of thing. A recap. Thank you. That's what it is. Recap. Recap. That's what I'm doing. More of recap. I wasn't trying to hear. No, she wasn't. No, I'm doing more recap because, you know, there's no court today and there's some motions that's being submitted. Yesterday, I read some of those motions because I went and got the transcript. So I was reading the transcript and someone sent me the actual footage. So I was playing the footage from that day, but the transcript, I still have the transcript. I will continue to do it later on, but you know, I was getting tired of reading. So that's the reason why they're helping me out by bringing this up so you guys can hear it. I do still have the transcript. I have the transcript from 2 hearings. Okay. So that's what I'm trying to do. Okay. Just trying to bring some information, jog your memory, do some recall. Okay. That's it.
A second bite of the apple here. We're talking about him. Judge Newkirk says it doesn't sound like she searched for anything. So that might have been a harmless error because the arresting officers discovered it and went out and told them. But I don't think we get to that hurdle because of the lack of authority shown to the court that they had permission to enter the house on the front side. So I don't think we get to that hurdle. There is no ruling on fruit of the poisonous tree. There was no previous ruling on the cell phones. To the extent Mr. Steele wants to make an argument about the other search warrant in the other case, that other search warrant.
Oh, okay. It was sucky. All right. So that was that one. So I'm going to stop this thing here. That was that. So I was just trying to. Do y'all want to hear her? Do you want me to continue that one? Because it did sound terrible, right? I was doing a better job reading, wasn't I? Even though I was tired, but I was doing a better job, wasn't I? So, so there's a lot of motions to suppress that Mr. Steele has submitted within the last couple of days. And remember the one I read yesterday had to do with when Mr. Mr. William and Mr. Stillwell, Mr. Mr. Jackson and Mr. Jones was in the car, and the police officer did not do the Miranda rights, y'all. They didn't do the Miranda rights. Y'all can go back to my yesterday's video. I talked about that. I also read the motion and everything. So I am just basically. Oh, you got the membership back? Pretty brown eyes. Okay. And all this senseless, they have already made up their minds. And bro getting. How do you say that, Mr. Monroe? Mr. Monroe says that bro getting to get like, I don't know about that. I don't know about that, Mr. David. And I'm just saying, because based on all the stuff, I guess you did not hear what I read yesterday. You probably need to go ahead and listen to my yesterday's motion. Because everything that they're putting on him looks like they're being suppressed. So they can't even talk about it during the trial. Recapping. They can't make up their mind if they haven't had all the evidence. If all the evidence is not going to be shown, I don't know. You're entitled to your opinion, and it's valid based on what the information you know. But it's best for us all to get all the information he's getting out, but not life, in my opinion. He's getting time, but not life, in my opinion. VK, that's what VK just said. But remember, y'all, we got to deal with what the law is. The law. If he got a good attorney to me, somebody said to me, like, they'd rather be a rich, guilty person than a poor, innocent person. Did you hear that? Someone said, this was an attorney, says they'd rather be a rich, guilty person than a poor, innocent person. Let that marinate for you for a minute. I think he's going to have time served because he's been in jail almost a year. If whatever he gets convicted, or if he gets convicted, he would already have time served because he already been there for a year. And then remember, state, you don't have to serve all the time. You do not have to serve all that time in state. It's not like feds. Fed is day for day, and 85% not in state. A rich, innocent person that becomes a poor, innocent person. Oh, you're right, baby concept. It does happen. It does happen. Oh my God, that is so true, baby concept. It is so true, because what they do, they drain the innocent person until they have no more money, and then they become a poor, innocent person. And that is so true. I concur on that one. I concur. Because they drain them so much. Yeah. They drain them financially. That's what the name of the game is. Drain until they can't afford to represent themselves, and they become poor. And you know what, Crushy? You know more than I do on this. Crushy knows more than I do. So you let us know what you know. Dr. TTH says, Doug has Kevin Lyles on his side. He will be okay. War of Laws. Hey. Here's some things that I have learned. Oh, I got some footage for y'all. Hold on, y'all. I got some footage. Let me show some footage. Let me tell you something, y'all. Yesterday, one of the guys shot the cameraman a bird, y'all. I'm gonna show it to y'all. He shot the cameraman a bird. Hold on, I gotta sneeze. Oh God, don't start allergies. Don't start with me. Y'all, hold on. Oh my God, it's starting with me. It's starting with me. I love. Hey, well, okay, here we go. I got some footage for you guys. You know, I always have it for you. I got to put it in my dark thing now because you know what happened if I keep it light. Sorry, I'm making noise. Sorry. Well, they got the bird yesterday by one of the defendant. I don't even know what's his name, but he shot a bird. He shot a bird yesterday. I was like, what? What's all that for? What's the bird for? He shot a bird, y'all. This is from yesterday's footage. Y'all. That's what I feel like this whole case is about. It's sad. The system is using these rappers that come up fast and a lot of money and trying to pin any damn thing on them. Bless you. Thank you, baby. Y'all, Bobby and Belle Biv is on Sherry's show. Funny. Bobby Brown and Belle Biv is on Sherry's show. Oh, Sherry, what's her name? Sherry Shepherd. Sherry Shepherd. Hey, Talisha, good morning. Is it morning that it's still? No, it's afternoon, y'all. Oh, my bad. What have I been doing today? All right, here we go. I'm going to show you guys. The guy shot us a bird, y'all. He shot a bird yesterday, and he thought it was funny. One of the defendant, he shot a bird at us, at the cameraman. He'll be okay, Sharon said. The camera guy. He should have shot it back. Watch what the guy do. Hold on, y'all. Oh, come on now. Is it not moving? Me and this thing be acting up. Hold on a second, y'all. Hold on. Let me go back. Here we go. Let's see. Yeah, this is from coverage from yesterday, and I'm going to show it to you guys. This is from yesterday. They are running their mouth like crazy. All right, hold on. This is the boring part. Hold on. Hold on. This all I did was just doing this. It was boring. It was boring. Hold on. Here we go. All right, here we go. This is from yesterday, guys. I was trying to see if I can get it a little bit. Hold on a second. A lot of time was wasted on this one right here. Hold on. Let's see. Okay, here we go. Go get some of the people now. Here we go. See how they looking at the camera, guy? Look at them. The guy in the burgundy, he's looking at the camera, guy. Yesterday was like no real productive day. It was them getting their thumb drive for. That's Nichols, guys. Now I'm starting to get these guys' name. That's Nichols. I think that's Nichols. Is that Nichols, y'all? I don't know. That might not be Nichols. Nichols has Mr. Sharp as his attorney. That's not him then. I don't know. I'm confused. I think that is Nichols, y'all. You gotta wait till the name come up. I think that's Nichols. I know the guy in the back with the blue shirt is Rod. Rod, yeah, little Rod. And Farley is on the right, on the left side of his attorney. Okay, Shannon, that's not okay. Never mind. Dr. TTH, I was wrong. But that is Nichols. See the name Nichols? That is Nichols. I was right. That was Nichols. That's Shannon right there. Shannon said deuces, y'all. Did y'all see that? Shannon said deuces. Yeah, the camera is pretty big, Trissy, and the courtroom is real small. They see the camera. Yeah, he is Harvey. You're right, VK. That is Harvey. His attorney is Harvey. No, he don't want the camera on him. Look at he look like, okay, why you got the camera on me? They do not like the camera on them, boy. The camera is a real big camera, and it's, they can see when it's who it's pointing at. See how he not even trying to look at the camera. Look, he not trying to hear that. Look. That's the mask. You know how the mask look like a turtle? Look at him. He do not want that camera on him. That's not the one that's gonna give the bird. The other guy's gonna give the bird. I don't even know the other guy's name. Little Darcy right there. And Trissy said I wouldn't look either. Look, none of them wants to look. See, he's looking at the camera. See, he's looking at the camera. See how he's looking at the camera, y'all? The one in the gray suit. Yeah, he's always smiling. He's a happy guy. Yeah, he do not want to look at that. Now here come the guys gonna meet that gonna give us the bird in a minute. You're gonna see him in a minute. Here we go. He's sitting right behind Kendrick. The guy's sitting behind Kendrick. Not the big guy. The other guy. That one right there. Watch him give us the bird, y'all. Watch him. Look. Ready? He just gave the bird. He gonna give it again. Watch. He gonna give the bird again. He's gonna tell Kendrick, and then he gonna go give us the bird. Look, watch. He's giving us the bird again. One more time. There we go. Y'all saw it. He think it's funny. Let's see that again, y'all. Let's see that again. Him giving us the bird. Hold on. He gave us 2 birds. 4 birds. He gave it twice. He saw the camera. He's like, I'm going to give him a bird. This one here, he just don't want to look at the camera. Yeah, I watched this yesterday. I was like, wait a minute. Did he just give us the bird? Did he just give us the bird? These two don't want to look at him. They're probably so tired of the camera. Watch somebody use this content now, because I said he gave us the bird. Somebody's in the bushes trying to see what we got right now, and they're gonna show it. Watch. Yeah, they're probably mad. You're right. He looked, and then the one that used the snack all the time, they're probably mad because everything. See, he's always happy. Look. I don't know what's his name. I don't know that one guy's name. A Mulligan? Okay. McMullen. Yeah, Mendes always laughing. That's BB right there. BB with the little twist. That's BB down there. The twist. That's Kendrick across the way with the burgundy shirt and the brown, look like brown suit. Now look at him with the fingers, y'all. Look. See him giving us the blurred bird. Y'all saw him? Look, now he gonna show him he giving us a bird again. Watch. See? Giving us the bird. Y'all remember it came from here. Watch it gonna try to steal it. They're gonna try to steal it, y'all. I guarantee y'all stroll the YouTube world, you'll see somebody saying, "Oh, the guy gave us a bird." Just remember I said that. Y'all saw it here first. Sharon says it, yo. You know it was. You know, war of laws. You know that's what's gonna happen. That is what's gonna happen. Okay, Nichols' attorney Harvey must have stepped out because you see, Sharp is over there right now. He must have stepped out. He must be doing something because Sharp is sitting over there with him. That's not his attorney. His attorney is the guy with the long ponytail, the white hair. Look at Thug's hair is done, y'all. It's nicely done. You see how Thug's hair is nicely done? Jeffrey's hair is nicely done. It's nice and neat. It's like redid. No fuzz, no nothing. This was from yesterday. They might bring him out early, Dr. TTH, because I remember Toria was telling us about when he was doing they would have people come and do their hair right before they have to come to court. I guess somebody who's like, been part of the system, they might allow them to do that. Because his hair is nice and did nicely and neat. It's very neat. See how neat it is? There go our boy. There you go. He doesn't eat anymore. He be all in tune doing his work. Look how serious he's looking. You said George Wallace, Dr. TTH. George Wallace. Yes, very neat. He's still looking at the camera. He don't like the camera. That guy, the one that gave us the bird, he does not like the camera. Look, he's got another bird, y'all. Look at him, another bird. Look at him. He keeps giving us the bird. He gave us 3 birds. Well, 6 birds altogether. He does not like the camera. Look at him. He does not like the camera. He's going to find another way to give us a bird. Oh, my God. Oh, Lord have mercy. He does not like us at all. He does not like us. He keep giving us the bird. Oh, my goodness. Everybody else is serious. They're looking at their case, reviewing their stuff, and he's there giving us the bird. Trissy says, as long as he doesn't moon us, it's all good. I don't want to see a moon. It's very easy to do. I used to twist my own hair. Had them for 15 years. Cut mine. Oh, where's he going? The judge gonna walk in a minute. Where's he going? Where's Mr. Adams going? The judge is gonna come in. No, not for a little while. Hold on a second. Let me fast forward it a little bit. Hold on. We sat there a long time. I'm just fast forwarding it a lot, guys. It's kind of boring. I was trying to show you guys the guy that was mooning us. I mean, not mooning. See, you got me saying mooning, Tissy. That's a lot of money. $1,000 and $1,550 every hour. Woo, TTH. Woo. That's a lot of money. $1,050 every hour. And imagine how many hours spent in a day here at court, and then the amount of months. Hey, KG. Imagine the amount of months. It's going to be like murder. That's a lot of money. Yeah, they are worth it. KG, you just missed it. We got the bird 3 times by one of the defendants. He gave us the bird 3 times. He don't like the camera on him. Wait a minute, y'all. Hold on. Y'all, listen, hold on, y'all. I gotta say something. Hold on a second. I gotta stop this one. Okay, I just want to stop there and do a little short commercial, y'all. Tasha K put down in her IG chat thing. She says, "Damn winos, we lost the appeal against Cardi B. Sad day, but I'm gonna be all right. I appreciate all your love and support throughout this fight. Today we throw in the white flag. What happened will never happen again. To Cardi B and her team, I apologize sincerely. We live and we learn. See y'all Wednesday on YouTube. YouTube and Tasha K Live." Yeah, can you believe she finally apologized? She finally apologized. Guys, she could have did this a long time ago, took down her stuff, and just now she's, $4 million in the hole now. That was really dumb. Okay, sorry. I just had to do a little commercial break on this old Tasha K thing, because I did that case as well. I was on that. I was on the ground on that one too. I have my old videos up. I'm gonna rearrange my videos so you guys can see that when I covered that case. I did the transcript reading on that case as well, and Oh, you're not up to speed on Cardi B? That was last year. Last year, Tasha K, Cardi B sued Tasha K because she was putting out some false defaming things about her, you know, saying that she had herpes, she was a prostitute, and she some other stuff she said about her. And so Cardi B took her to court, and she lost. Tasha K lost. Tasha K is a blogger, you know, YouTube blogger, Dr. TTH. So she lost. She lost the appeal. She appealed the case, and she lost the appeal. And there's nothing else they can do about it. Yep. Tasha K was in a lot of mess. You know, sometimes being popular, doing nasty and ugly thing and lying, it's not going to help. It's not going to help. Some people should learn from that. Hint, hint. You're right, TTH. They love to lie. They love to lie. They love to put fake narrative out there about people instead of the truth. That lie might give you numbers, but it's not going to help you out in the long run when you lie about somebody. Yep. People don't understand that. You can't do that. You can't tear up somebody's life. There's a couple of people on YouTube that needs to be off because they just love to lie. They love to lie, Ann. Oh, I wanted to bring something up to you guys. Hold on. Hold on a second. I wanted to bring this up to you guys. I know. Hold on just a second. Let me get this information out to you. Did they grant something for Jeff Favor? No, not yet, Slime Pit. Not yet. No, not yet. I was just doing a recap of what, the suppression that the judge had granted to Doug back in December. And also I talked about the new motion from yesterday. I talked about it yesterday. So, and I was just doing a recap because I went and got the transcript from when the judge gave the ruling, and I was reading that to the people, those who were, who don't know anything about it, who were not familiar with it, and just a chance for us to just review, get ourselves acclimated. Some people don't know about the case, and just, giving them some information. The judge has not. There's a whole bunch of motions that are still out there that the judge has not addressed yet. That's because he's still doing the hardship. In fact, group number 5 has just come in, and as of Wednesday, they're coming in to start the hardship. Nothing new. Absolutely, Sharon. Nothing new. So they're going to start the hardship from group number 5. Then you have group number 6 coming in next month, April 24th. And then you have group number 7, which will be here on May 19th. So you have all these groups. Thank you, Slime Pip. Yeah, it did go well. Thank God. I won my case, and new stuff is going to come down because, you just can't let stuff lie like this, Okay. All right, let me finish playing this for you guys. This is just footage from yesterday from court. Nothing big. Just, just for you guys to see what happened in court yesterday. There was nothing big. Today is an administrative day, so there's nothing in court. I'm not in court. I'm at home. But tomorrow I'm back at court. This is when they're going to be doing the jury hardship continues for group number 5. Okay. And please hit the like button, please. If you don't mind, hit the like button. Yeah, it's boring. I'm trying to push it. I'm gonna wait till the judge come in so he can give y'all update what's happening. Look at him putting a turtleneck all over his head, y'all. Look at him. He got that turtleneck. The guy in the burgundy, he got the turtleneck all over his head. You still in the bed? Lucky you. Look at him. He got the turtleneck all over his head. Did they tell him to take it down, or he just moved it? You know, I like to people watch. This is fun for me. Observe people. What do people do when nobody's looking at them? Yeah, you got some more in you too? I said you got some more in you? Yeah, it was cold. It was cold, Dr. TT. It's been cold the last couple of days. It's been cold the past couple of days. Oh, they're having a good time in there, aren't they, guys? Today is not that bad outside. It's let me see the weather. What's the weather for tomorrow today?
All rise. Superior Court of Fulton County, Atlanta District is now in session. Honorable Chief Judge Judge Glanville preside. All right, good morning, ladies and gentlemen. Good to see you. It's still morning. Got another 6 minutes.
Wait a minute, y'all.
Absolutely.
Wait a minute, y'all. Did that young man just have his hand in his pants when he got up? I'm not going to go look at that again, but wow. Okay. Wow, that's disgusting. Hold on.
Yes. All right, good morning, council's interested parties. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. Let me go ahead and take roll to begin with. Mr. Beebe, Mr. Partridge. All right, good morning. Mr. Stillwell and Mr. Sharp, good morning.
Tanya wanted me to read one.
Oh,
okay.
Mr. Boss, I see
Yeah,
Mr. Boss sitting over there.
Hold on.
Okay.
Tanya wants me to rewind. Tanya, okay, I'll rewind. Tanya is so funny. Hold on, y'all. Here we go. The judge is about to stand up. The guy in the burgundy right here is the one who's going to have his hand in his pants. Hold on. Ready? Go. Yeah, you got some more in you too? I said you got some more in you? I am more. Now watch, y'all. His hands in his. He keep his hand in his pants, right? His hand is all his ear and all that. But watch when they get up. Look, his hand is. Why is his hand still down there? He got the left hand moving around, but that hand's still in his pants. I didn't mean to catch that. Ew, I wouldn't touch his hand. Lord have mercy. Mm-mm. Yuck.
All rise. Superior Court of Fulton County.
Now watch him get up. Look his hand, y'all. Look where his hand is. See how disgusting that is?
It's still
That is
morning.
disgusting.
Got another 6 minutes. Absolutely.
Hello?
Hi, good morning, council's interested parties. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. Let me go ahead and take roll to begin with. Mr. Beebe, Mr. Partridge. Hi, good morning. Mr. Stillwell and Mr. Sharp, good morning. Oh, and Mr. Botts. I see Mr. Botts sitting over there. Okay, thank you. Mr. Farley and Mr. Menendez, good morning, gentlemen. Mr. Williams, Mr. Steele, Mr. Adams, good morning, gentlemen. Mr. Mender, Ms. Fagan, good morning. Mr. Kendrick, let's see, Mr. Wolstein, good morning. Mr. Healy and Mr. Matthews, gentlemen, good morning. Mr. Myrick and Ms. Bernard, good morning. All right, Mr. Nichols, and let's see who we have here. Is it Miss, I know, Mr. Nichols, and we have Mr. Harvey and Miss Westmoreland, but Mr. Harvey's not here, is that right?
Oh, I'm here, Mr. Fox.
I know, are you standing in for him?
I am indeed.
Okay, okay, all right, okay. Thank you.
Yes.
Mr. Adams and Ms. Calland. Mr. Blaylock and Mr. Hill. Good morning. Mr. Dorsey and Mr. Jimenez.
Good morning.
Mr. Evinger, Mr. Johnson, good morning. Where's Mr. Johnson? Oh, there he is. Okay. Good morning, Mr. Johnson. Yeah, you have bad timing. Very bad timing. All right, Mr. Ryan and Mr. D. Williams. All right. Anybody I missed? Oh, good morning, representatives from the state. All right. Okay, all right. I understand it from, and I appreciate y'all's patience. I had some other unrelated business I had to take up this morning, but as I understand it, the thumb drives arrived around 1000 hours this morning, and through the, I have it on good authority, the work of Jimenez and Associates, that you've all had a chance to get it.
All right, that's it for this one. Let me just go ahead and end this so I can bring up the other one. Jeff done saves more lives than everyone in the courtroom. Oh, Tanya, it's too late now, Tanya. You know why? Because they already hopefully they didn't he didn't touch the doors and stuff. Hopefully he didn't touch the doors. That's just nasty. Yeah, touch the doors. The doors. Yuck. Did they touch the doors? All right, here we go. Let's finish listening to what happened yesterday. This is the second part of yesterday's stuff. What happened? Nothing happened. We're just showing the coverage from yesterday, just a video. But oh, you talking about, okay. Veracity, there one of the young men had his hand in his pants while he's in court, and then he had to stand up. His hands were still in his pants. And we happened to catch that. And a couple of them, and one other one gave us the bird 3 times. You know, just stuff like that. No big deal, just things like that.
A thumb drive, and they have checked, you've checked those thumb drives, and everyone has a working thumb drive copy. Is that correct? All right, I'm gonna just go run the roll and just make sure everybody's got a thumb drive, okay? Yes, in working order. Mr. Partridge for Mr. Beebe.
Yes, sir.
Mr. Shart for Mr. Stillwell.
Yes.
Mr. Menendez for Mr. Farley.
Yes, sir.
Mr. Steele and Mr. Adams for Mr. Williams.
Your Honor, we have received multiple, I did not check. I did not check, two of them, Mr. Adams, and such.
Do you have a working copy though?
Yes, sir.
Okay, then you're good. Okay, all right, Ms. Fagan, on behalf of Mr. Mender.
Yes.
And I assume that by you saying yes, you do have a working copy, okay? Unless I'm told otherwise. Mr. Kendrick, I should say Mr. Wilstein on behalf of Mr. Kendrick.
We have a working copy.
Thank you, sir. Mr. Matthews on behalf of Mr. Huey.
We have a working copy.
Thank you, sir. Ms. Bernard on behalf of Mr. Myrick.
Yes, Your Honor.
You have a working copy? All right. All right, Mr. Botts on behalf of Mr. Harvey and Ms. Westmoreland, on behalf of Mr. Nichols, you have a working copy?
I have a working copy from Mr. Stillwell, and Bruce has 3 working copies for this.
Okay, all right. Ms. Callan, do you have a working copy, madam, on behalf of Mr. Adams?
Yes, Your Honor.
Mr. Hill, do you have a working copy on behalf of Mr. Blaylock? Thank you. Mr. Jimenez, I assume you have a working copy for Mr. Dorsey?
I do.
All right, and Mr. Johnson, do you have a working copy on behalf of Mr. Eppinger?
I did. I guess.
Okay. All right, and then finally, Mr. Williams, do you have a working copy on behalf of Mr. Ryan?
Yes.
All right. Ms. Love, on behalf of the state, do you all have a working copy?
We do, Your Honor.
Okay. Anybody I miss? Okay, folks, thank you for your patience again. As tomorrow is your administrative day to continue to review this afternoon as well as tomorrow. Do you all have plans or have you set a time to meet late tomorrow to discuss your joint strikes?
Your Honor, we decided to, I believe defense counsel asked that we meet at 9:00 a.m. and 8 a.m. if the court will permit us to do so. And that time and place is good for the state if the court permits us to do so.
What date, madam? Is that the Wednesday?
Yes, Your Honor, Wednesday morning prior to the court at 9 a.m.
All right, okay, and then at 10:00 hours on Wednesday, we will meet in fact, Ms. Von Kelch, as of Wednesday, Thursday, and Friday, will entertain those particular jurors that have come in, will be coming in to fill out their questionnaires. And more than likely, what we will do in the pendency of about from 10:00 hours to about 11 is just address those joint strikes and put them on the record. And then it is the court's intention that in the afternoon from about 2 to 5 o'clock on the 22nd for us to go ahead and do hardships, begin the hardship process, okay?
Yes, Your Honor.
All right. Yes, Does anybody else have any other ministerial inquiry of me? Anyone?
Not from the state.
Okay, all right. So, did you have something, Mr. Jimenez?
I do have a concern for future discovery, so like, I got the drop 10.
You got your what? I'm sorry?
I got the drop 10 of discovery. I got it. But the state requested a brand new hard drive. They couldn't provide what I would be using. And a brand new hard drive is more money, new money. And I provided a brand new hard drive, but they couldn't figure out how to get it on. I've been able to copy it to 3 of the co-defendants from the one that I got. In the future, I am just respectfully requesting for them to provide the brand new hard drives, they can't use it. Because I can't keep putting money out of my pocket.
Well, then why don't you ask, is that for you or for anybody else?
Oh, at least I'm asking for me. I can provide it, the hard drive, I can use it, they can put it on there and give it back to me, but I can't keep buying new hard drives because they don't know how to put them on. But like right now, as I'm sitting here, I made 4 copies for the co-defendants. And that's fine, I have no problem with doing that, but I can keep spending money on discovery. That's just my request.
All right, maybe that's something you can talk offline with Miss Love and her team, and if worse comes to worse, and of course, I'd invite you to file a motion. I'll certainly take it up. Okay. All right. Yes, Miss Bernard.
Yeah, on Thursday, just to confirm, I think you said you were starting at 10:30 to 12, and then 3:30 to 5.
Well, you appear at 10:30, okay? Because y'all are notoriously never on time. So we're going to start on at 10:45, hopefully, okay? And again, we will do about an hour's worth of work or thereabouts. Concurrent with that, Miss, we may not be able to do anything other than because Miss Von Kelch and her team will have. That'll be one of those days that she'll be entertaining people coming in to fill out questionnaires. So I doubt we'll convene, but I don't know what we'll be doing. And then we will do the bulk of the hardships from the afternoon late from 3:30 to about 3:30 to 5:30. So.
And I asked because I want to make sure that the court is aware. I want to let the court know. My co-counsel, Ann Long, will be here.
Who?
Ann Long.
Has she entered an appearance?
Yes, we met an appearance a couple of weeks ago.
Then we can probably get her officially on the record at that first block of time that we have in that morning on the 23rd. If you just remind Mr. Chamberlain and myself, we'll go ahead and get that done for you, okay? All right, thank you, madam. All right, Mr. Johnson, did you have something, sir? I saw you around on the corner wall. Just a second.
I just want to reiterate what the state had said with regards to this meeting on Wednesday.
Okay, yeah. So you all are going to meet on Wednesday morning at 9:00 in courtroom 8F. You are welcome to meet to discuss that. All right. So tomorrow, I get a gazillion questions about this. Can you all excuse me for just 1 second, please? Hello.
Yes, sir. You're next. I have to do Weinstein first. I just told you.
Okay, councilors, thank you for your patience again. All right, do I have anything else from anybody else that wishes to take any other ministerial inquiry? Tomorrow is, yeah, I keep getting a lot of inquiries, okay? Tomorrow's an administrative day. Your clients will not be here. Okay, does everybody understand that? They'll be here on Wednesday. They'll be here on Thursday, and they'll be here on Friday, because those are dates that we will have, in fact, jurors in the building, and we may have to take up business. All right. Unless there's anything else, thank you for your patience, counsel, and I will talk with you all on Wednesday morning around 10:45, okay? All right. See you then. Thank you. You're welcome. What's up? Yeah, he has a good time.
I hope y'all don't touch his hand. Don't touch his hand. Don't touch. Look at his hand. Don't touch that guy's hand. Don't touch his hand. Yeah, I'm telling them, don't touch his hand. Don't give him a high five. Don't give him nothing. Because that guy's hand is nasty. I'm drinking my tea, y'all. Maybe the thing is hurting his leg. But he had his hand inside of his pants. Hey, Jay. It's still in. I wouldn't touch his hand for nothing at all. I ain't touching his hand. Nope, not I. Never. Nope. Trissy, I'm sorry. I'm not touching his hand. Hey, Jay, there's one that gave us the bird a couple of times. They don't like the camera anymore. Now, all the officers that's watching my channel, y'all know, you better make sure y'all keep hand sanitizers in your hand. Dr. THH says, TTH says, it's just the pee. You know what? Nobody wants to touch nobody else's PP. One of the guys in the back, he gave us the bird. If you rewind it earlier, it's like in the earlier part, he gave us the bird. He gave us 2 double birds at once. Let's see what else we can get out of this. Hold on. That's the one kept his hand in his pants. He's talking. Mr. Stillwell talking about the camera. That guy back there, his name is Adams. Okay, that's Adams right there. This one, he's smiling at the camera. That one's smiling at the camera. You see him? He's smiling at the camera. That's Adam right there. That's the one who's supposed to be gave the Percocet. That's Adam. They're looking straight at the camera now these days. Now that's the one who gave us the bird, the one with the suit back there. He gave us the bird. Oh no, sorry, Jay. That the suppressed item came from the last back in December. That was nothing updated. If you look at my thumbnails will show you that it's from, I was reading the transcript from December. That's what the transcript went from, the hearing that they did on the 17th of November, but the transcript is from December. So that's what that was from. Adam's hand. I don't know where, I didn't pay attention to Adam's hand. I had enough of the other guy. I don't need to see anymore. But well, guys, I'm about to end this live. We've been on here almost 3 hours, and I just wanted to show you guys that. And thank you. Shout out to the person that gave me the actual footage from that motion, because I was reading the transcript. Dr. TTH said that was funny. That was not Adam. It says Adam. It says Adam on the thing. On his front of his, what's the name? It said Adam. Not the attorney Adam. Adam, the guy, the other guy. The one that you know, the one, what's his name? His name is Adam. Hold on, let me go tell you what the name of the guy is. Hold on. No. Adam was the second guy that Trissy says Adam's hand. Adam is the one that had on the burgundy suit, right? Right? The one that we just looked at. Oh no. The one that was playing with his pee-pee. Wasn't that Blaylock that's playing with his pee-pee? I think that was Blaylock that was playing with his pee-pee. Yeah, that Blaylock. Oh. I don't look, pretty brown eyes. You see where I'm at? I'm in my house watching my little TV with you guys, right? We're watching our little movie on this set here. I stay out of that mess that's going on YouTube. I don't want nothing to do with that mess. And hopefully nobody brings me in it anymore. Adam was playing with Trissy. I didn't want to see Adam playing with his stuff. I don't want to see none of them play. Y'all crazy. I don't want to hear that. We're just doing commentary. You know what, Dr. TTH? You need to stop it. Dr. TTH says, watching porno and playing with his ding-a-ling. But okay. On a serious note, guys, it was fun. I know that's right, Sylvia. Stay out of it. It's too much drama. Absolutely, y'all. I will stay out of the nonsense. I will stick to what's happening here on this side of the world. Those computers are there for a reason. No, Dr. TTH, those computers for them to review their discovery. That's what they have on those computers, discovery stuff. They have to be abreast of what's going on in their case. You are so funny. Don't you think the officers would have seen what they have on there by now? Because they keep it down. I guarantee you, if one of them had something like that up, the officers would have pounced on it right there. Trust me. Because I remember one time the officer got in it with one of the attorneys about him giving one of his clients something to eat after the judge had made a ruling for them not to bring any food to their client. So I know for a fact that is not the case. I know for a fact that is not the case. They're not going to do something like that. Trust me, you can have 2 screens up and it's not illegal. But they wouldn't want them watching that. I mean, with the guards and the deputies and all those that's in the courtroom, I don't think they would let them watch that stuff. Trissy said they are there for us to discover them playing. Okay. All right, guys. You guys have been wonderful. I thank you guys for this afternoon. It's been great. But I got to get some work done. I got to learn how to do these videos so I can have stuff rolling for you guys. I got to sit here and learn this Final Pro Cut. Then I have to look. I'm looking for something to do, work from home type of thing, because I need some income, all that good stuff. So I will catch you guys later. Peace out. Have a wonderful, wonderful, wonderful day. You're welcome. You're welcome, guys. I'll see you guys later. Bye. I need to screen out. Okay. Bye.